Christopher, tell me.
Lord, I'm told that your Lordship has the original supplemental bundle.
I have now been given replacement bundles. Given that I've marked up this version, I think I've decided to stick with this version unless there proves to be some document that I'm missing.
Yeah, well, that's the point, Lord. I understand there's no document missing. Your Lordship has more. Had facilitated down to 350, I think, was the page limit. Your Lordship got the first edition, which had slightly more in it. So you're that benefit. As such. Right, but unfortunately, I understand there's no even page numbering difference, so we'll have to see how we. You can't say it's like 6 pages on.
With the help of the contents page, I shouldn't really have a problem.
Thank you. Now, we were discussing the Maxpower application, and the first ground of appeal, which I call the G4S point, we asked the question, have they actually pleaded that the members of the group executive, who are not otherwise de jure directors of SC plc, are de facto directors of SC plc, which is what they need to plead, according to Mr. Justice Mars's decision. And I took you to the particulars of claim where there's no such pleading. The original RFI response where we asked them the question, it wasn't pleaded. And the second RFI response in relation to relevant misconduct, where they identified individuals, but only in respect of relevant misconduct, and made a case for de facto directorship of those individuals, but not in relation to the group executive. And that was the position as it stood before the judge, and quite bluntly, the judge ought to have struck out as appropriate that allegation, insofar as it alleged knowledge of those members of the group executive, because there's no allegation that those members of the group executive were the de facto directors of SC plc. Now, the claimants have sought to plug that gap by proposing amendments to their further information, which I'll just show you so that you see where the land is sought now to lie, which is the supplemental bundle, its final form, tab 28, page 349. And just to remember the context of this, maybe best to begin at 340. We looked at it just before the short adjournment. There was a request in relation to PDMRs in respect of the relevant misconduct allegation, where they identified the individuals that they rely upon as PDMRs and de facto directors for these purposes. What the claimants have sought to do, it can be accepted, but they've sought to do at 349 through this further information document in response to a question, giving an answer to a question that hasn't actually been asked, is to allege, or to purport to allege at 215, each member of the group executive was either a de jure director or a de facto director of SC plc by virtue of their position on the group management committee or the board of the bank. So the gap, which was a gap before the judge, is sought to be filled by this amendment to the further information. There's no application as such, but your Lordship can see what it is. And that amendment has been opposed, or is opposed by the bank, amongst other reasons, on the basis that there's no actual material in support of the allegation. The test of de facto directorship requires an examination of the relevant person's conduct. And we can see that from the case. Don't need to go back to it. This is merely a generic allegation about positions on the board. So even if that were introduced, we would submit it doesn't do the job. But in any event, wasn't before the judge. It's not actually before this court in any event. So that's the gap. So that's what we call the G4S point. The judge also realised that for a number of people, it's about 20, there's simply no allegation at all. The second point we've taken, and the second and third points really run together. The second point we've taken is what we call the en bloc point, which runs as follows, that the allegation of dishonesty, which we end up in the paragraph 77 of the Particulars of Claim, is a generic allegation of dishonesty against either 50 or up to 50 individuals, rather than an allegation which identifies, first of all, who the individuals even are, or let alone the material against which the inference is sought to be drawn that that individual is dishonest. We submit that as a basic procedural safeguard, it is incumbent on a claimant making such an allegation against individual members of a supposed group that they identify with clarity the basis upon which dishonesty allegations are made against each individual. Now, only as an illustration of the problematic nature of this pleading and the difficulty the recipients of these allegations have been put, is the fact that there was confusion leading up to the hearing as to who was even in this group. We say it's a basic safeguard. You identify who they are and why dishonesty is being alleged. We don't have that. Right until the hearing, there was uncertainty as to who was even in the group at all. Just to give you a rundown, we saw the reply, which said that it was those members of 70.1, 70.2, and 70.3, which is about 50. Mr. Shrimpton's evidence in front of before the last hearing said words to the effect of, the defendant has said it's uncertain who's a member of this group. There's no uncertainty at all. It's just those in paragraph 70.1. So Mr. Shrimpton's evidence before the court in advance of the CMC was there was about 32 people in the group. And it was very clear in the pleading. In the skeleton argument before the hearing last time round, we were told that was an error. In fact, it was all three groups, in fact 50. Now, in a sense, that's a jury point, but it's more than a jury point we would submit. When you're making such serious allegations, that's why one must identify who they are and why the allegations are being made. Otherwise, we end up in this situation where generalized allegations are made across the group without the detail that's required for such a pleading. Nor is it an answer to say, as has been suggested, well, it's all the claimants can do at this stage. They can only plead on this generic basis, because they haven't pleaded on a generic basis for the other part of the case. They have identified 12 PDMRs and have purported to identify the basis on which that allegation has been put. They haven't identified individual PDMRs, alleged PDMRs, on the Maxpower side of the case. So it's not an answer to say they can't do it. They have done it when they needed to. They haven't done it here. So that's the second point. We say as a matter of principle, it's wrong to plead generically against 50 individuals in the allegation of dishonesty. The second point sort of blends into the third, and the en bloc point is a sort of mask of the problem of the third. No doubt the reason the en bloc pleading is made is that there isn't the material to plead a fraud case or a dishonesty case against this group. And we submit the third point as an inadequate basis to allege dishonesty against these individuals, or at least the pleaded basis is inadequate to allege dishonesty against these individuals. And it goes back to the inferential point in primary facts. No doubt that this allegation of dishonesty, which is the claimant's allegation rather than Brutus's allegation, is an allegation of inferential dishonesty. And yet we submit that the pleaded case doesn't come close to tilting the balance of dishonesty against any one of them, let alone 50 of them. Now, the starting point here is that the conduct which is said to falsify the representation, so that's the beginning of the cause of action, is the bribery scheme itself. One can see that if you go back to the pleaded case, which is the core bundle, tab 7, page 121. Particulars of claim, I showed you this earlier, 121, 29.2, alleges the actuality of bribery, which is defined as the bribery scheme. So the allegation from the claimants is that there was a bribery scheme as so defined. And if you then go to 126, these are the particulars of the allegations of falsity. And for example, if you pick up 43, so the bribery compliance representation, that's one, I think I showed you that as an implied representation, was untrue or misleading. The bank had not implemented or maintained adequate anti-bribery. Such systems were inadequate in that they permitted the bribery scheme to commence and continue for several years. So the falsity derives from the existence of the scheme. And going forward, of course, the knowledge, therefore, would have to be of the scheme, and the dishonesty by reference to the scheme. Now, and as we know, for guilty knowledge, it's actual knowledge or recklessness, or dishonest omission or dishonest delay. Yet, the claimants, we submit, do not even make the allegation of actual knowledge of the bribery scheme, let alone recklessness. And if they do, they certainly don't allege any particulars to support that allegation. we can go back, please, to paragraph 75, which is the sole basis on which the pleaded allegation of dishonesty is advanced. This is, I'm afraid, the factual matrix.
Sorry, you said paragraph?
Paragraph 75, page 146.
Thank you very much.
It's the sole basis. This is the factual allegation alleged. And you'll see from number 75.1 the reference to an article, and the inference. This refers to the awareness, and we submit not incidental, that there's no even indication of what the awareness is. To run this case, it would have to be awareness of the bribery scheme, but they don't, on the face of it, go that far. It's awareness. But in any event, the matters relied upon may just about support a case of awareness of an allegation, just about, possibly, but they certainly don't support or begin to support an inference of knowledge of the existence of the scheme, let alone dishonesty in relation to the scheme, which is the critical part of the claim. The article referred to, it's in the bundle, we don't need to look at it, was published, funnily enough, doesn't make an allegation of dishonesty, doesn't make an allegation of knowledge, simply makes an allegation that is an alleged, has been an allegation of wrongdoing, and a suggestion that the bank may be aware of the allegation. So at its highest, what is relied upon in 75.1, at its very highest, is an inference that some members of the defendant were aware that there was an allegation of bribery. Equally, 75.2, which is the only other pleaded particular, refers to, as we saw, the engagement of certain law firms to investigate. And the conclusion, again, at the end of that paragraph, such steps would not have taken place without knowledge of SC plc's group executive. Again, they don't indicate what their knowledge is. We submit tellingly, because they couldn't, based on that material, plead knowledge of a bribery scheme. At its best, again, knowledge that there was an allegation of bribery being made. But even there, the facts alleged are that it was being investigated by 3 professional firms. So 2 law firms and PwC were engaged to investigate the allegations. That is not, going back to the Keckman test, that is not consistent with an allegation of dishonesty. And those are the only facts which are pleaded in support of this allegation of dishonesty on the part of 50 individuals, even up to 50 individuals. The article in 75.1, which doesn't say it, and the fact in 75.2 that there were professionals involved to investigate. Neither, we submit, comes close to a pleading of primary facts to support the conclusion, the inference, that up to 50 individuals are more likely than not to have been dishonest in relation to this matter. We submit that's nowhere near enough for an allegation of fraud in such a case. Nor is there anything, just to be clear, in the reply which takes the matter any further forward. If you go back to the reply, page 301, we looked at this also, 24 under the heading Indonesian bribery, and most of this addresses what I referred to earlier as the Maxpower directors, and various points about their involvement and non-involvement in various allegations. In these paragraphs, there is no mention of the group executive, let alone anything to support the case that the group executive might have been dishonest. So these paragraphs don't add to, relevantly, paragraph 75. And that is it. We submit there isn't even, on the face of it, an allegation in 75 of knowledge of the bribery allegation. But even if somehow that paragraph were to be construed to include such an allegation, even though it's not expressly made, the material relied upon doesn't begin to support an allegation of dishonesty by inference. The fact that it's against 50 individual people makes it all the worse.
Well, I think the inference must either work against all 50 or against none of them. So saying that it's, as it's pleaded, at least one, doesn't really work as it is.
No.
It's either all or none.
Either all or none. My own block point may not be an independent point in itself, but it works together in my submission. That this pleaded this way. My submission would be the same were this allegation to be made against on this head, an individual person. So if it had said in 75.1, it's to be inferred that X had awareness, my opposition would be the same, because the awareness of what, not pleaded, and the material doesn't support the allegation made. So the Lordship is right. The argument is the same. I do, however, submit that somehow it's worse. Well, not somehow. It appears more abusive in my submission when it's spread against 50 people as well.
Well, you can make the point, can't you, that if they could identify which individuals did have the requisite knowledge, that they would have done so.
Yes.
What they've just simply said is that every single one of these 50 knew.
Yes, knew something. So it does make it, say, my primary submission is the same, because what they rely upon doesn't do for one, let alone 50. The fact that it's against 50, I think, does make it worse, because it's an indication of the fact that there's no actual material against any of them. And that takes us back to Your Lordship, and that's it. That is the pleading, as we know, of dishonesty in relation to Maxpower. Just so Your Lordship sees the last bit, if you go back to the supplemental bundle, tab 28. This is the second set of particulars, and the claimants have sort of tried to fill this gap too, or at least part of these, insofar as the pleading point have tried to fill this gap. If you look at page 342, 1A in red, they now want to allege, again, this is a question that's not been asked in this request, they now want to allege that one or more members of the group executive knew or turned a blind eye to the bribery scheme. So that's an addition to what they pleaded in 75, where tellingly they didn't plead that, either knowledge of or blind eye knowledge of the bribery scheme, highlighting the gap before. But again, that can't serve the purpose, because you can't just suddenly allege that if the material you rely upon doesn't support it. Can I therefore go back to the judgment on the Maxpower issue, which is a core bundle, page 71, tab 5, page 71. And it begins, I think, at 68. What the judge, 67 and 68. 67 mentioned the inconsistency I referred to, but there it is. That's just a fact, not the basis of the application. 68, he then says it is relevant to note that the claimants rely on the same individuals comprising the group executive for their Section 90 claim in relation to relevant misconduct. However, SC not sought to strike out that allegation as being too vague. That's just an error from the judge of the pleading. The Section 90A relevant misconduct claim is directed to 12 individuals we looked at in the further information. So they do identify 12 individuals. They do say they're de facto directors, and they do make a case, for what it's worth, of knowledge. That's not the basis of the pleading. The group executive is a creature that exists in Maxpower. So that just an error from the judge. There's no crossover. It's then said SC sought further information in relation to the group executive for the purpose of the claimant's allegations in relation to misconduct. Again, that's not right. We didn't. The further information I showed you specifically looked at the claim in relation to relevant misconduct, which wasn't about the group executive. It also asked whether the claimants were alleging those were not their directors. The claimant's response listed as best they could a number of individuals alleged to have the requisite knowledge, yes, in relation to relevant misconduct, and the basis of them being de facto directors. These responses were given, as I have said, in relation to relevant misconduct. Mr. Chapman submitted they apply equally to the group executive against whom the bribery scheme allegations are made. Well, they don't, because that wasn't the question and it wasn't the answer. The group executives are different in the structure from the relevant individuals. And I'm not seeking to strike out those 12 that are identified, but for the unidentified group executive. I think that was the judge's answer to what I call the G4S point. He said, well, if you look at the further information, it's all the same. And that appears to be from a misreading of the pleadings to begin with, that the group executive applies to the relevant misconduct, which it doesn't. So that's what somebody then, I think, concludes what he says, the group executive point. And then 71, he says that prior to disclosure, not possible to be more precise. And they've requested information, have to wait for it. 72, despite the unfortunate inconsistencies, the allegation of the individuals within the group executive of PDMRs is adequately pleaded at this stage. That appears to be on the basis of this misunderstanding of what the group executive pleading was. The judge doesn't appear to ask whether, for those 20 or so who are non-de jure directors said to be in the group executive, there was an allegation they were de facto directors. Had he asked that question, the answer would have plainly been no. That's the, if you like, the G4S point. 73, he then sets out factors relied upon in the pleading, which we've essentially looked at, but mainly 75 from the particulars of claim. And paragraph 74, he says that adequately pleaded at this stage, the claimants advance a credible case, members of the group executive must have known about the bribery allegations from the whistleblowers. This was before the bribery scheme was exposed by journalists, entitled to take that case to trial. Now, the judge picked up on, but we submit was an error in doing so, the fact that at its highest, and giving them quite a lot of benefit for that, the claimant's case is there was inferred knowledge of somebody of an allegation. To that extent, the bribery allegations point is right. What the judge didn't follow through, we submit, is that in order to sustain their case of dishonesty, the way it's pleaded in any event, to sustain a case of dishonesty, they would have to show, as they've sought to allege in their amended further information, actual knowledge or recklessness about a bribery scheme. And therefore the judge, with respect to looking at slightly the wrong target, and had he looked at the right target, he'd have realised that the pleaded facts do not support that allegation. And really, on the Maxpower point, it is as simple as that, because the pleading in a sense is as simple as that. And we submit it doesn't on any of you get through the test. Can I just pick up 2 points before I sit down on my friend Skeleton on Maxpower, which is at tab 11 of the appeal bundle. Actually, 3 points. Page 353. (36.2) refers to the matters pleaded in paragraph 75 in the reply, and says those matters are only consistent with at least one member of the group having had the relevant knowledge. Now, I don't want to spend too long on that. That's not actually the right test. The particulars don't have to be only consistent with that. The primary facts have to show the inference more likely than not. Nevertheless, we submit it's difficult to imagine how that allegation, Luke and my friend to develop, can be a realistic assessment of the pleaded case, given the matters I've shown you. Those matters in 75.1, 75.2 are only consistent with relevant knowledge, is, we submit, frankly impossible. 36.3.2, it's then said, I think having realised that they need to establish knowledge of the scheme as opposed to knowledge of the allegation, it said, well, if you look at 75.2, you see a reference to the fact that 3 founding members had their contracts terminated. It's to be inferred, therefore, as alleged, that one or more members of the group executive knew that Maxpower was taking such steps, and therefore the bribery scheme amounted to more than mere allegation. This is the closest I think I've got to where they try to assert that the pleaded facts are sufficient to support a case of dishonesty, but in a sense exposed by that as being inadequate. There's no pleaded case as to even why those people had their contracts terminated, who actually knew about the contracts being terminated, whether it's had anything to do with bribery at all, let alone whether they supported a case of dishonesty. So in a sense, that's the high point, as I understand it now, of the way the claimants would want to put their case. But we submit that those pleadings are clearly not sufficient. And the only other point on Maxpower, paragraph 37, where it said, well, the Maxpower allegation per se is going to trial in any event because the Section 90 claim is not being struck out. So it's a sort of like a sort of case management response to some of that, which is there's no point in engaging in the issue. To which we say 3 points. First of all, if I'm right that the case is an inappropriate and inadequate plea of fraud, then it ought to go as whatever the case management consequences, because the court should not countenance an inappropriate claim of fraud on the pleadings at all. Secondly, this is a discrete allegation which has a significant impact on the shape of the trial, in circumstances in which if the Maxpower Section 90A claim is in, then there's a dishonesty allegation to be investigated, 50 PDMR knowledge allegation to be investigated. That's completely different to the investigation under Section 90. Section 90 claim is in relation to prospectuses. The way the sequence goes, the only relevant Section 90 Maxpower claim is the last one in 2015 because of the timing. The issue then is whether the people doing the prospectus had reasonable grounds to believe the prospectus was properly made. So it's an entirely different inquiry to whether PDMRs in the group executive had dishonest knowledge. And the third point in terms of the shape of the case, just so you have this information available, the Section 90A claim across the piece, for all of it, is said to be worth by the claimants £1.4 billion. That's the scope of the Section 90A claim for relevant misconduct and Maxpower. The Section 90 claim for the 2015 prospectus, which is the only conceivably relevant one for Maxpower, is said to be between £2 and £5 million. So that would, if I'm right in my submissions, I invite the court to allow the appeal in relation to Maxpower, certainly not to allow Maxpower to continue if it's a faulty pleading, simply because there's a very small tail, which would then wag the dog. So, my Lord, subject to any other questions that I get to in my appeal.
Thank you very much, Mr. Beltrami. Mr.
My Lords, in summary, you know that we resist the appeal on the overarching basis that the judge was right for the reasons he gave in his judgment. With respect, we do suggest that a telling feature of this appeal is that the appellant effectively seeks to re-argue the application it made to the judge, making many of the same submissions that were addressed to the judge, but crucially, and we say critically, failing to identify any clear error of law or approach in the judge's judgment. Effectively, they say it is to be inferred that the judge must have made such an error because he did not, in the event, find in their favour. But we say that when one steps back and analyses the grounds of appeal that have been presented, they disclose no error in approach or application of the relevant principles by the judge, who was right for the reasons that he gave. Now, we welcome the clarification that no friend gave at the outset of his oral submissions, that really this appeal is concerned with whether the judge was right not to strike out various parts of the particular claim, and is not really concerned with summary judgment. The summary judgment aspects of the application were pursued and are pursued in writing by the appellants. And I only mention that now, so to speak, to clear the decks, because the judge had to deal with both aspects and did so in his judgment. And so when, for example, he's criticised for referring to and relying upon some of the evidence that was filed on the applications below, we say that criticism is misplaced because he was dealing with both an application under Part 24 and Part 3. My Lords, With that short introduction in mind, I propose to deal first with the judge's approach to the relevant principles and the way he applied them in overview, before then dealing with, secondly, the Brutus grounds of appeal, grounds 1 and 2, and then the Maxpower grounds of appeal, grounds 3, 4, and 5. My lords, when it comes to the relevant principles, there was rightly little between us before the judge, and the judge's approach in summarising the relevant principles applicable to strikeout applications under CPR 3.4 is not challenged on this appeal. And my lords will have seen that in the judgment at paragraph 42, 4 bundle tab 5 at page 63. And my lords will see at the bottom of page 63, paragraph 42 begin, and the judge's reference to both Regis and the well-known passage in Easy Air, before he goes on to identify 5 particular points, which my lords will see from paragraph 43, my learned friend did not then dissent from. And my lords, just by way of emphasis, I suppose, at this stage, the authorities in our submission could not really be clearer, as recognised by what the judge recalls here, in showing that the summary procedure provided by CPR Rule 3.4 and indeed Rule 24 is not appropriate for complex cases where there are disputed issues of fact and or where the issues engage developing areas of law. And as my lords will know from our written skeleton, we say both of those considerations are engaged here. It is also...
Are you really concerned with the developing area of law?
Well, my lord, we are, my lord, only, I think, insofar as the test for PDMR is concerned under FISMA and the decision of Mr. Justice Miles in G4S.
Are you disputing that Mr. Justice Miles was right?
My lord, no, not on this appeal, as we did not before the judge. But what we'll come on to see is that what Mr. Justice Miles has said is that a PDMR, for the purposes of the Section 90A claim, must either be a de jure director or a de facto director, or possibly a shadow director. But what Mr. Justice Miles also left open was precisely how that test for de facto directorship falls to be applied in the particular context of a Section 90A claim. And as we'll come on to see, he expressly recognised that the concept and the test may admit of some elasticity.
I can't quite see how the test for de facto directorship can depend on whether this is a FISMA claim or not. And there's authority on what constitutes a de facto director, including in particular a decision of the Supreme Court, House of Lords, in which Mr. Justice Green was counsel, as I remember.
My lord, yes, but when we'll come to it, the position on G4S leaves the door somewhat open as to how the test falls to be applied in a FISMA context. And that's only really relevant because we're not asking this court to, neither party is asking this court to make a determination on this appeal as to what the test is for de facto directorship in a FISMA Section 90A claim. It's only relevant when we come to see how the case was pleaded. Because jumping ahead, Mr. Justice Miles' decision came after very many of the pleadings in this case were filed and served. So the parties were taking particular positions absent the decision in G4S, which are still their positions to an extent on the pleadings, which have not yet, if I can put it this way, caught up with the decision. So on the one hand, in summary, the claimants were pleading a wider case than would now be permitted following G4S as to the meaning of PDMR, whereas the defendant, the appellant here, is pleading a very much narrower case, and still does. So the defendant's case is that the only PDMRs are de jure directors of the PLC. So you have it to an extent two extremes. The claimant's case has somewhat moved on, as we'll see through the further information, and the judge was correct to find that they do rely on de facto directorship on both the Maxpower and the relevant misconduct elements of their claim. The defendant's case has not. It remains that the only PDMRs are de jure directors. And my lords, the only other point perhaps worth noting at this stage when just looking at the judgment and where the judge records the test for strikeout is that, as my lords will know, the application did not seek to strike out the claims in their entirety. That it was an application that focuses on particular claims or particular parts of claims. And as I'll come on to develop, the application reflects a somewhat inconsistent approach on the part of the appellant in terms of what it regards as being adequately pleaded and what it seeks to challenge, where in fact the basic approach of the claimants to both parts of their claim, relevant misconduct and Maxpower, has, as my lords will expect, as being the same. My lords, in terms of the approach to pleadings and the judge's approach to the relevant principles, can I invite my lord's attention, please, first of all, to page 60, the bottom of page 64. In fact, one can probably start at the very next paragraph, paragraph 43, first of all, please, which is where the learned judge noted that, first of all, Malone Friend did not dissent from the principles applicable to strikeout applications, but focused far more on the requirements of properly pleading such a case, particularly one of fraud or dishonesty. Now, I invite my lord's attention to that because I think there was a suggestion during the course of Malone Friend's oral submissions that somehow the judge in his judgment had not addressed or not adequately addressed the gravamen of his submission, which he makes again to my lords today, that the pleading was inadequate and failed to satisfy the requisite standard. It's clearly something that the judge had in mind, albeit, as we'll see, before the judge, the focus of Malone Friend's attack was somewhat different to the focus of his attack today, and his attack before the judge included as one of its core elements the suggestion that the claimants had to demonstrate the steps that they had taken to verify their pleaded case, and that somehow that should be apparent, and then, having been apparent, should be the subject of consideration by the court. So, having identified Malone Friend's position and identified the case upon which he relied, Clark, he then, as we see at paragraph 44, refers to the Duchess of Sussex case, and then at 45, my submission in relation to the third element of the test set out by Lord Justice Warby in that case. And then at paragraph 46, one really sees the point that I was just seeking to develop, which is that Malone Friend before the judge, as the judge records here, seemed to be suggesting that something more was required, and the claimants either had to show that they had taken steps to verify their claims before they pleaded them, or to plead fully all the evidence to support the allegation of fraud or dishonesty. And it's perhaps that latter part of that submission that's the gravamen of Malone Friend's appeal on the Brutus allegations before this court, albeit the former no longer appears to feature. And what the learned judge then does is he refers to the authorities that Malone Friend had addressed him on, and then at paragraph 47 finds that the cases referred to by Malone Friend were more concerned with whether the pleaded facts are sufficient to found an allegation of fraud or dishonesty, or whether they could also be consistent with, say, an allegation of negligence. And he then recorded that that was not the issue before him, which is whether there is sufficient evidence for the plea of fraud and dishonesty to be made, and whether enough of that evidence has been pleaded. Now, the judge then goes on to note what Mr. Justice Salesley then was said in Nokia as to the measure of generosity that might be provided to a claimant pleading fraud, particularly where there was an information imbalance between the claimant claiming fraud and the defendant. And also he cites the further case that the learned friend referred to again today, federal deposit, and what was said there. So having identified the relevant principles, the learned judge then moved to deal with the Brutus allegations and the application that related to them. And at paragraph 49, my lords, the learned judge, identified the 2 points upon which my learned friend before the judge concentrated. The first, as my lords will see, was the suggested requirement that the claimant should have sought to verify the Brutus allegations so as to ensure that there was a sufficient foundation in the evidence for making them. And the second was that the primary facts in support of the allegations of fraud should have been pleaded. So the first of those not really pursued on appeal, the second is. The learned judge then recorded that the attack being made on the pleading had originally been based on the argument that the pleadings were defective because they did not actually make the Brutus allegations themselves. And you'll see what the learned judge said there in paragraph 50. And the learned judge then correctly recorded that those points were not pursued once it became clear, if it was not before, that the claimants are making the Brutus allegations for themselves and averring that they are true.
And just to be clear, even in the reply, as Mr. Beltrami pointed out, there's a reference to your position being such and such, so that it might be said that the statement of truth attaching to the reply merely confirms that that is your position. Is the reply, or indeed are the particulars of claim, to be understood as meaning that you are saying that you believe the allegations in the relevant allegations in the Brutus complaint to be true?
They are, yes, my lord. And I'll show you why that's clear in any event from some of the other passages in the pleadings. Now, what the learned judge then does is summarise the submission that I made to the effect that the pleading of the Brutus allegations had been properly done and was sufficiently particularised. And my lords will see that at paragraph 51. And having summarised those submissions, that in effect there was a proper pleading of fraud, the judge found at paragraph 52 that he agreed with those submissions and that he would dismiss the application before going on to give further reasons as to why that was so. So what the learned judge is correctly identifying is that at least part of the attack on the pleading before him, as it is on this appeal, is that the pleading of fraud was not properly particularised and was not a proper pleading of fraud. And he effectively dismisses that part of the application and does so agreeing with the submissions that I made as to why the plea was a proper one. What the learned judge then does is first of all deal with the structure of the pleading. And he begins there at paragraph 53. And one sees that having traced through paragraphs 20 to 27 in subparagraphs 1 and 2 as to how the relevant misconduct, including Brutus, is pleaded, he comes to paragraph 27 at subparagraph 3, which he records as coming in for much criticism from a learned friend as being a wholly inadequate plea of fraud. And then he says, however, as I submitted, or as I pointed out, the evidential basis for paragraph 27 is found in paragraphs 21 to 24, which is then summarised in paragraph 27 as the allegations that the claimants rely on. And he then quotes paragraph 27. And then finally, in subparagraph 4, the learned judge notes, as is the case, that the defendant only sought to strike out subparagraphs 27.1 and 27.2. And the learned judge says that this was not really explained, but it must be based on its supposition that those two subparagraphs are wholly dependent on the Brutus allegations, whereas the others are supported by the allegations based on the 2019 settlements. Now, we'll come on when we come to see the pleadings that the learned judge's sense of puzzlement there is well founded in that it's clear that all of paragraph 27 is based both on the 2019 settlements and also the Brutus allegations. So it is somewhat curious that the application focuses only on those two subparagraphs of the 5 that are pleaded in paragraph 27.
But that point doesn't go anywhere. I mean, if 27.1 and 27.2 are bad, why does it matter that the claimant, that the defendant might have attacked any other subparagraph?
Well, my Lord's obviously right about that. If that's right, then I'm fortunate that the learned friend has focused his attack in that way. But it is a curiosity of the application. And again, really comes back to one of the points which doesn't, I accept, take me very far, as to the inconsistency in approach, that there are parts of this pleading that are premised on effectively the same approach with which the defendant takes no issue in terms of their adequacy as a pleading, whereas others they do, where in substance there's no real distinction between the approach that's being adopted.
Well, part of that's because they like to strike out those allegations which are going to lead to massive disclosure and huge amount of factual inquiry.
Well, they say that, my Lord. In fact, as matters have progressed during the disclosure process, the additional disclosure required by the Brutus allegations is relatively limited. I think an additional 2 custodians. And similarly on Maxpower, we suggest that the degree of overlap is very considerable, particularly if the Section 90 claim is remaining as it will. So, my Lords, just pausing there. The learned judge correctly identified the question which he had to ask himself, namely, was the claim based on the Brutus allegations properly pleaded? Was the pleading in effect fit for purpose? And he answered that question in the affirmative. And he also then went on to address the additional attack, which is whether the claimants were under an additional obligation to show how they had verified what they had pleaded.
Where does the judge explain why he thinks the pleading is fit for purpose?
Well, that's a combination, my Lord, of the paragraphs we were just looking at. So first of all, paragraph 52, where he accepts the submissions that I made, which he summarises at paragraph 51. And it then goes further, because later in the judgment, at paragraph 55 and 56 and 57, this is really the fitness for purpose point that the learned friend took issue with, the judge recalled that the defendant had been able to plead to the Brutus allegations in their defence without making any reservation as to their inadequacy or their right to apply to strike them out on that ground.
But supposing that there was no difficulty at all for a defendant in responding to allegations, they knew exactly what was being alleged, they had no difficulty pleading back to it, that doesn't necessarily answer the question, does it, as to whether it is a proper pleading?
Well, Lord, it doesn't answer it in and of itself, but it's a relevant consideration for the judge to take into account as to whether this is an adequate plea or not. He obviously has to start with the face of the pleading itself, and he obviously considers that, as we've seen in paragraphs 51 to 53. He returns to that at the end of paragraph 59, where he records that, in his view, it seemed to him that this had been adequately particularised.
But all this is saying, all you said in paragraph 51 that's recorded, is that it was adequately pleaded.
My lord, yes.
And so that really doesn't take us much further forward, because the question we're addressing is, and the judge should have been addressing is, was it adequately pleaded? It's a bare assertion, isn't enough, is it?
But, my lord,
And at 55, again, it's not addressing whether it's adequately pleaded, only that it could be responded to.
well, my lord, the first thing I would submit in answer to that is that these paragraphs have to be read as a whole, as the judge's consideration and evaluation of the adequacy of the pleading. In summarising the pleading at paragraph 53, the judge finds that paragraph 27 has its evidential basis in its foregoing paragraphs 21 to 24. This is all after accepting the submissions as to the adequacy of the pleading, of course.
Where's the analysis?
Well, we respectfully suggest, my lord, that the analysis is there. The assertions being made in an adequate and evidential basis has been pleaded for the Brutus allegations, and the judge is saying here, when considering the pleading is adequately pleaded, including because the evidential basis for the allegations in paragraph 27 are to be found in paragraphs 21 to 24. In addition to which, he refers to, as we see elsewhere in these paragraphs, the submissions that have been addressed to him at paragraph 51, including as to the pleading being supported by a statement of truth, and there being no basis for suggesting that...
But the pleading has to be supported by a statement of truth, so that takes it nowhere, does it?
My lord, of course, although this is in the context of the judge having already referred to the decision of Mr. Justice Sales in Nokia, where the requirement that a pleading is verified by a statement of truth, together with counsel's professional obligations before pleading allegations of fraud, are referred to as some of the important procedural safeguards that are imposed in the context of pleas of dishonesty and fraud.
I follow that, but they can't be all that there is, otherwise there would never be a scope for a strikeout application. I mean, one trusts that counsel will have performed their professional obligations. The court, I don't think, is really concerned with that. There has to be a statement of truth. If there isn't, then that certainly does matter. But supposing that you have a pleading verified by a statement of truth, which counsel has thought it proper to put forward, it's still open to a defendant to say, no, this isn't good enough.
I accept that, of course. That must be right. The point that I'm seeking to address here is that somehow the suggestion that somehow the judge has gone wrong and failed to consider that which he should have considered, and I think the attack is being made by my learned friend, took account of matters which were not open to him. And I think that was the attack being made particularly on the statement of truth and the professional obligations point. They are, of course, in and of themselves not sufficient if the pleading itself is inadequate. But the judge was entitled to take them into account when considering the position as a whole. And fairly read, the judge here is finding that the pleading itself is adequate.
But what about his reliance upon the concession in the agreed case memorandum? Do you say that was right?
Well, my lord, I think the position there is that goes to the fitness for purpose argument, as I've characterised it, is that part of one of the most important roles of the pleading is to set out a case with sufficient particularity that it can be understood both by the opposing party and the court. And that's all the more important, as we accept, in the case of fraud. It goes back to the point my Lord Justice Phillips was making to my learned friend in the context of SOFA. If you're going to make an allegation of fraud, it has to be specifically made, and you have to plead adequate particulars. and we of course accept that as the test, and we say that this pleading complies with it.
But what I'm asking you is, in paragraph 57, after setting out what was said in the case memorandum, the judge says it is difficult to read that as anything other than acceptance by SC that the claim, including the Brutus case, was properly particularised and that it was adequately pleaded. Do you support that statement?
My Lord, I do, and I do so on this basis. It is part of the picture, not the full picture, but part of the picture when it comes to considering whether this pleading is fit for purpose.
No, I'm asking, do you support his finding that you cannot read that statement in the case memorandum as an acceptance by SC that the claim was properly particularised and adequately pleaded?
My Lord, yes, because it reflects the fact, as is the case, that the defendant was able to plead in response to these allegations, plead a positive denial, positive case denial.
It's not talking about being able to plead to it. This is saying it was an acceptance that it was adequately pleaded. Do you say that was an acceptance that it was adequately pleaded? How can you say that?
Well, for the reason that the judge identifies, is that the parties have agreed a case memorandum that records the position as is quoted in paragraph 57, that the claimants allege the 2019 settlements and the Brutus complaint evidence relevant misconduct on the part of the bank, which is then further particularised at paragraph 27 of the Amended Particulars of Claim. Now, the attack that there's then being made on the pleading is that the structure of the pleading does not work because you have not provided, I would characterise it as proper particulars. My learned friend describes it as sufficient primary facts, I'll come to support your plea. But I don't think the learned judge here was saying that my learned friend was shut out from challenging the pleading on his application. It's more, again, when he's considering, which is why I've described it as a fitness for purpose point, when he's then evaluating, is this pleading a proper plea? Is it fit for purpose? Does it adequately set out a case so that the defendant can respond to it? And the court can then make case management directions in relation to the disputed issues, including as to disclosure. The judge is saying yes, and saying given that the parties were able to agree what they agreed in the agreed case memorandum, it's then quite difficult to see how the defendant is then saying, well, no, the pleading is not fit for purpose. It doesn't disclose an adequately pleaded case in fraud.
The case memorandum refers to the strikeout application.
It refers to the fact of the application being made, which is why I've put it as I have. Is the judge, certainly as we understand it, is not saying that the agreement of the case memorandum somehow prevents the defendant from challenging the pleading.
I think this is completely at odds to what my understanding of what a case memorandum in the commercial court is meant to achieve. If setting out what the claimants allege is some sort of concession by the other party, that it's properly particularised or adequately pleaded, then that's going to completely change the approach of parties to what they put in a case memorandum. I find it very troubling.
Well, Lord, I probably can't say too much.
I mean, it all starts with the rubric at the top of a case memorandum, which completely undermines the top.
Well, my Lord, I think that's why I've put it as I have, which is that the parties have diverged, I think, on what they say the judge means in this paragraph. I think.
But the point, sorry, forgive me. The point is that there doesn't seem to be any substantive reasoning here. I mean, whether the conclusion is right or not may be a different matter. But there's no substantive reasoning. The judge seems to have dealt with this by saying, Mr. Chapman says it's adequately pleaded and has got a statement of truth. I agree. There was some sort of concession in the case memorandum they've been able to plead to it, and there's some evidence from the solicitors as to why the pleading is okay. But there's no actual, can you point us, as my lord asked you to a while ago, to where the judge actually analyses the pleading to see whether or not it is in fact an adequately pleaded case of fraud substantively?
My lord, yes, and he does that in paragraph 53, where he goes through the pleading.
It's not, is he? He's just simply setting out the structure of it there.
Well, except in subparagraph 3, he finds in answering, I think, at least part of the attack on the pleading, by explaining how the pleading works, that the evidential basis for the pleas in paragraph 27 are found in the earlier paragraphs 21 to 24. And then, my lord, one has to read that together with the earlier paragraphs 50, 51 and 52, with, of course, everything else he says. But then he comes to paragraph 59, where he again records the attack from a learned friend that the claimants were pleading only conclusory allegations without identifying the facts upon which they are based.
And the difficulty then is, he says, but as I have said, it seems to me that this has been adequately particularised. Where he never really, when you look to see where he said that, you look rather in vain.
My lord, we take that as a reference back to everything that appears in the foregoing paragraphs, and in particular paragraph 53. But again, I slightly go back to the point of context, which is that before the judge, he was dealing both with the adequacy of the pleading point and the summary judgment point. And some of the analysis here obviously is addressing both parts of the application.
There may well be very good reasons why your pleading is sufficiently pleaded, many of which we debated with Mr. Bolshrami this morning. But do you really maintain that those were considered by the judge? Because it seems to me quite plain he didn't grapple with them. And it seems to me what you need to do is to grapple with them, not just simply say the judge grappled with them.
Well,
he didn't.
But I was coming on to look at the pleadings and effectively to address to this court the submissions that I addressed to the judge below, in which he summarises and before accepting, which is the answer to the attack that's been made on the pleading by my learned friend. But I begin with the pleading, with the judgment, and the judge's treatment of the pleading, so that I hope I've made clear to my lords where the judge at least addresses the issues, and where we say he was right, at least right in his conclusions, and right to accept the submissions that we addressed to him below. Now, my lords, I think in seeking to answer the questions asked me by my Lord Justice Phillips, I have addressed the remaining paragraphs through to paragraphs 62 and 63, where the judge deals with the other various attacks, including the alleged requirement to verify the allegations in the pleading, which he rejects. Can I, perhaps before turning to the pleading, just make some submissions to develop a point recognised by the judge in the paragraphs which we were just looking at, which is the information imbalance between the defendant company on the one hand and the claimant shareholders on the other. Because this provides, in our submission, important context to the pleaded case and indeed the attack upon it. The first point is an obvious one, is that this is not a he said, she said, dispute between the two protagonists who were party to the relevant negotiations or misrepresentations. Rather, the claimants are shareholders in a company who say that the published information was, to put it in its most general, misleading and seriously so. The second point, flowing from the first, is how are the claimant shareholders to come to know of the alleged misstatements in the published information? And we submit that effectively there are four likely candidates. In some cases, perhaps rare, there may be a mea culpa from the company, perhaps following a takeover or an audit report or something of that nature. The second is there may be government or regulatory action and investigations. The third potential source of information are whistleblowers. And the fourth might be journalistic investigations into the company. And they themselves may, to a greater or lesser extent, rely on the other sources which I've identified. Now, as we'll see, there is a combination of at least some of those here. And in particular, we have whistleblowers and journalistic investigations coupled with, of course, the 2012 and 2019 settlements with the US and UK authorities. What, however, follows from that point, the likely source of information or sources of information, is that a claim of this kind is almost inevitably premised on knowledge, information, and ultimately evidence of third parties rather than the claimants themselves. And in our submission, we say plainly, although it appears that the appellants dispute this, there is nothing inappropriate, still less impermissible, in pleading a claim, including a claim based upon and alleging dishonesty, on such evidence or information from third parties. And with respect, and I'll come on to develop this, my Lord Justice Phillips was correct in identifying the type of example of a case that my Lord did in terms of the former bank employee who tells the customer that they've been defrauded. One can think of perhaps less exotic examples, such as the road traffic accident, where the claimant and a third party are both injured, and the claimant, for whatever reason, perhaps because of their injuries, can't remember anything about the accident. But the third party can give evidence that it was the defendant who was responsible for the accident. There's nothing impermissible about the claimant in those circumstances, relying on what the third party says about how the accident happened to plead their claim. And to take the analogy further and perhaps tie it back to my Lord Justice Phillips' example, similarly, nothing impermissible if the third party first brings their cause of action in respect of their injuries, and the claimant, learning of that, then effectively adopts the allegations as to how the accident occurred that the third party has made. The next point is that we submit there's nothing inappropriate or impermissible in the claimants attesting to their belief in a claim based in that way on information provided by a third party. The next point we seek to make is that, by contrast to the relative lack of information on the part of the claimant shareholders, in this type of case, a FSMA securities case, it is the defendant company that effectively holds all the cards in terms of information. They will, or each the company will know the true position in respect of the alleged wrongdoing, and it, the company, will know the identity of its PDMRs and the likely knowledge of its PDMRs. And that's quite important when we come on, as we will, to see where you have a relatively opaque corporate structure, as you do here, and a defendant company that is unwilling to provide further information as to its corporate structure and as to who its likely PDMRs are. And I should perhaps just introduce the point here so that the Lords will see why I make it, and I'll come on to develop it. My learned friend said much about the second RFI response that we provided in answer to questions about the relevant misconduct. True it is that the defendant asked the claimants for further information about the relevant misconduct, and in particular about PDMRs. And significantly, it asked about the identity of PDMRs for the purposes of the relevant misconduct claim, while not asking equivalent requests for information about the Maxpower claim. Part of the claimant's response was to say that the claimants would provide further particulars of the PDMRs if the defendant itself provided some further information about its corporate structure and those within it exercising managerial responsibility. The defendant then provided further particulars in relation to the relevant misconduct claim, which then enabled the claimants in turn to provide the further information which you've seen, and which I'm afraid I'll have to take you back to in due course, where the 4 became 12 in terms of particular individuals said to be PDMRs for the purposes of the relevant misconduct claim. But no equivalent process has been gone through for the Maxpower claim. And that's just quite a vivid example of how there is an information imbalance and how the information balance then flows through into the pleaded cases. And the final point perhaps on this, before moving on, is that we do submit that the defendant's approach would effectively denude the statutory scheme of any real effect or teeth. It would provide, or at least risk providing, a remedy available only in theory but not in practice. If it really is right that the claimants are required to plead out in such detail as my learned friend would have it, so as to effectively plead all of the evidence, and that's really what he means by primary facts, it's evidence, upon which they will rely on at trial, and to do so prior to disclosure, then that would effectively prevent any of these types of claims being brought at all. And that's before one puts into context that, as a general rule, there is no requirement to plead evidence. Indeed, it is to be discouraged. And that this attack on the pleading is taking place before there's been disclosure. But we submit, thankfully, that's not what the rules or the law require. Now, my Lord, that's what I was going to say about information imbalance for the time being.
In which case, is that a convenient moment for the break?
Indeed, my Lord.
you just tell, easy if you tell me so I can see stuff based on
We're just checking the figures.
yeah.
What a magnitude they'll be right. So, so point one was the Brutus only such produce of 140,000 documents.
How many was families?
340. That's before looking at the overseas data.
Okay.
Good go on.
Yeah.
One nuance on that is some of those documents could be produced by other such as well. So that's so maybe we have to look at some of them anyway. And then the second point is just obviously documents that we're going to have to review in any event. We're going to have to review them for different purposes.
Okay. At least we got at least they agreed to publish judgment.
Yeah, we're just saying that we'll get that.
Yeah.
It's a crap judgment with no reason.
Yeah.
But probably.
It's unlucky.
Yes. No question at all.
Looking. I can't see anything.
Is there others?
Is it just my problem? Was it?
Mr. Chairman.
Lords, before turning to the pleading itself, perhaps just one or two further points of context. The first is to take a step back and to be clear about what the relevant fraud is. The claim is not for relief directly in respect of the breaches of the US sanctions regime. The claim, as my lords will understand, is for relief because of misstatements and omissions in the published information. And the claimants allege that the statements in the published information were rendered inaccurate by reason of the relevant misconduct. They also allege that the statements were made fraudulently in the sense of Section 90A because a PDMR knew those statements to be false or were reckless as to that. And it's that really that's the key pleading of fraud and the key element of the cause of action that's being asserted in these proceedings. It happens that some, quite a lot as it happens, but by no means all of the relevant misconduct is itself said to have been dishonest too.
But that can't exonerate you from providing proper particulars of the alleged Brutus dishonesty.
My lord, no, but what it does do is provide the context against which the adequacy of those particulars falls to be judged. And it will flow into the fitness for purpose argument and the fitness for purpose test that the judge applies, whether the pleading adequately particularises the underlying relevant misconduct, which then is said to render the published information false. And one has to have a degree of realism about this in our respectful submission. It is highly unlikely that even following disclosure, that when it comes to the trial, the judge and the parties will be considering individual transactions allegedly made in breach of US sanctions, as opposed to internal reporting about a body of transactions made in breach of US sanctions with Iranian entities. And that's why it's relevant context in terms of judging the adequacy of the particulars provided.
But, I mean, at that stage, if not before, you will have to identify why anything was in breach of US sanctions.
My lord, yes, but it's much more likely that that will be done at a higher level, i.e. this body of activity, as reported internally, which is why it was known to the relevant PDMRs, was in breach of US sanctions because it comprised transactions with Iranian state-backed entities or terrorist organisations and so forth, rather than, we suggest far less likely, an analysis of thousands of individual transactions themselves. And that's why we make the point by way of context. The other point about context, and like my learned friend, I'm cautious about making anything that might be characterised as a jury point, but nonetheless the context here is that this is a defendant that has admitted wholesale, multiple, serious and deliberate breaches of the US sanctions regime. It, Standard Chartered, entered into the 2012 settlement admitting breaches of the US sanction regime. And we now know, because of the 2019 settlement, that to the extent that that represented a mea culpa, it was incomplete because it did not extend to covering all of what are now accepted to be breaches of the US sanctions regime. And it was for that reason, the incomplete nature of the 2012 settlements, that we then have the 2019 settlements, both in the US and in the UK, pursuant to which Standard Chartered admitted further serious misconduct in breach of US sanctions. Now, whether or not Standard Chartered had previously misled the US authorities in entering into the 2012 settlements, and there's an issue about that. On any view, the fact of admitted deliberate breaches of US sanctions, coupled with an incomplete admission of those breaches, is plainly very serious. It provides a historical pattern of repeated and serious misconduct of the most serious type. And we would suggest no more than this, that is not an entirely unpromising background against which to make the allegations of misconduct that are pleaded in the particulars of claim. Now, turning to the particulars of claim, and my learned friend has shown you very much of what I need to show my lords. Can I invite my lord's attention first to tab 7 of the core bundle, page 118, please, and paragraph 24 of the particulars of claim. Now, my lords know from learned friend submissions that paragraph 24 follows 3 earlier paragraphs and their subparagraphs, which relate to the 2019 settlements. And paragraph 24 then goes on to introduce the further allegations upon which the claimants rely, arising from the Brutus complaint.
What does the first sentence of paragraph 24 add?
Well, my lord, in many ways, nothing. One of the submissions I was going to make in due course, having gone through the pleading, is that it would have been perfectly proper for this pleading to simply have made the allegations that are made in paragraph 24 without identifying the origins or basis for them. So the pleading could have said 24.1, the 2019 settlements addressed a relatively small subset of the course of conduct by the bank in violation of Iran's sanctions. And similarly, 24.2 could have pleaded as it does to Project Green. The fact that paragraph 24 goes on to identify and say what the source of these allegations happens to be a whistleblower, Mr. Knight. He, through Brutus, has actually made these allegations in proceedings in the United States. It is, to a certain extent, a plea of unnecessary evidence.
The trouble with that is that if you simply had that and couldn't refer to the Brutus complaint, it would be a very thin pleading.
Well, look, it may be very thin, but we would say it would still be a proper pleading when read. And one of the points I'm coming on to make is that one has to read 24 with 25 and 27. But in answer to my Lord Justice Phillips' question, assume for a moment, perhaps close to the analogy that my Lord put in the learned friend, that instead of incorporating Brutus and bringing the proceedings in the United States, Mr. Knight had instead walked into the claimant's solicitor's offices and unburdened himself as to what he, as a former global head of transaction banking at the bank, had experienced and witnessed, enabling paragraph 24 and 27 to be pleaded. Now, in those circumstances, it would not have been necessary, may have been desirable, but it would not have been necessary for the pleading to have identified that the source of those allegations was a whistleblower. And one can see in certain circumstances where the identity of the whistleblower would have to be protected and preserved.
I mean, what's tricky about this? Well, there's more than one thing that's tricky about this. But one thing that's tricky is that the way you do it in paragraph 24 is you don't at that stage say you believe any of the complaints. You say these things were alleged. And I think actually that then allows Standard Chartered to plead in a very general way itself, because it's responding to the allegation that there was an allegation. So that's one aspect of this. For this to count for anything, it has to be taken as meaning that you allege that these things happened. But supposing that you hadn't explained where all this came from, as I understand it, in substance, you would have had 24.2 to 24.4, because 24.1 is surely too general to just work on its own, and 24.5 doesn't really deal with the substance of it.
Well, 24.1 would come and flow from 24.2 and to 24.4.
I mean, maybe you could have put it as a conclusion at the end, but the substance of it would have been 24.2 to 24.4.
Well, that's probably fair, if I may say so. But one then has to, of course, go on, just pick up on the point of whether it was always pleaded that this was misconduct that the claimants themselves were averring. If one reads on to paragraph 25 at the bottom of page 119, what's pleaded is that the claims concern the misconduct described above, insofar as it formed the subject matter of the 2019 settlements and the Brutus complaints, and that's then the definition of the relevant misconduct. So we are saying in terms, both for those parts of the 2019 settlement that we plead to in paragraphs 21 and 23, and also those parts of the Brutus complaint that we plead to in paragraph 24, that those comprise the misconduct, which is then defined as the relevant misconduct. So whatever ambiguity may have existed because of the introductory wording to paragraph 24, at paragraph 25 it is, in our submission, being made clear that the allegations in paragraph 24 are being relied upon as allegations of misconduct by the claimants. And that then feeds into paragraph 27, whereas the judge said further particulars of the misconduct are provided over paragraphs 27.1 to 27.5, the evidential basis for which is to be found in the foregoing paragraphs.
When you say the evidential basis, you really mean the particularisation of which.
Or particularisation.
And without referring to the Brutus complaint, I mean, take 24.4. The complaint specifies, well, that on the face of it says what the complaint says. It doesn't say whether it's true or not. But then it says, well, if we ignore that, the pleading would be a number of transactions with named Iranian entities and customers which the bank did business, reading differently, were unlawful in breach of sanctions and contradicted the bank's assurances. I mean, that would be so unparticularised.
Well, look, one can certainly see that a request for further information could then be made about that paragraph, but to suggest that it would then be in and of itself liable to be struck out, absent a request for further particularisation, reminding ourselves that no request was made here, we would suggest is wrong. That the pleading pleads, even before one gets to the cross-references to the particular parts of the Brutus complaint, adequate particulars of what it is said was done, namely breaches of US sanctions and breaches of US sanctions which extended beyond the 2012 and 2019 settlements, and particulars of how that was done. So it was done pursuant to Project Green, which is then explained, including as to whom within the bank Project Green was known. It was done using the OLT3 online portal and so forth. So what one has the essential complaint, namely deliberate and systemic breaches of US sanctions, together then with further particulars, or what Malone and Friend would describe as primary facts. We say it's the proper question is further particulars of that allegation set out in paragraph 24, and then moreover in paragraph 24 an explanation by way of further particulars as to where those allegations are derived from, both in general, namely the Brutus complaint and Mr. Knight the whistleblower, and by then particular reference to paragraphs in the complaint. And the relatively short point is that is, in our submission, a perfectly proper way to plead that case.
We're just looking at paragraph 24. The first sentence, no, it doesn't go anywhere. There's no further reference to what the financial press reported or the whistleblower allegation. Is that right? I suppose whistleblowers are referred in 24.5. But what the financial press reported goes nowhere.
Well, it may do is the answer, is that it may be thought that was a preemptive and defensive plea with one eye on limitation. Namely, in setting out both the particulars of the allegation, but also the narrative as to, so to speak, how matters developed. It may turn out to be important, it may not, but it was July 2019 that those reports appeared in the financial press. So it's not. It's not.
But in looking, what we're doing now is looking at the plea of fraud or duty and whether it's adequate. And I think one I'm going to use that first sentence doesn't take it anywhere.
Well, Lord, that's probably fair.
So then we come on to references to the Brutus Pleadings. It refers to it being incorporated by Julian Knight. It doesn't actually say any of the information comes from him.
My Lord, that's right, save for the later reference to whistleblowers in 24.5. But it's right that he's.
Where does that say that Mr. Knight is a whistleblower?
My Lord, it doesn't in terms. You're of course right. It doesn't say.
I hadn't understood when I read it that it was being suggested Mr. Knight was a whistleblower until I saw other references. It doesn't. Then 24.2. Help me with this. The bank's course of conduct. Course of conduct was a deliberate, concealed organisational structure. I don't understand what that means. How can a course of conduct be an organisational structure?
Well, that's a reference to Project Green being an internal bank project known to high-level bank officials as pleaded there, also concealed but deliberate. The purpose, or here pleaded mandate, for which was to develop strategies to evade the Iran sanctions.
Well, what does it mean by organisational structure? Does it mean... I just didn't understand what that means in this context.
Well, there was a deliberate structure put in place within the bank for the purpose of evading US sanctions on Iran.
And then it says the mandate of those responsible. So that was what they were instructed to do.
Yes, the instruction and intention, namely to evade the sanctions.
So who instructed them? Who instructed whom?
Well, that will be a reference back to the high-level bank officials, and then further forward.
So the high-level bank instructions instructed people responsible for Project Green to develop a strategy. Is that right?
My lord, in summary, yes, that's what's being alleged. And so Project Green is one of the particulars of the allegation of relevant misconduct that one sees them pleaded at 27.1.
Can I suggest one thing? If we look at the Brutus complaint, there are cross-references in 24.2 to paragraphs 42 A, B, and D, I think.
Yes, that's supplemental bundle tab 3, page 44.
Can we take it that you are effectively incorporating A, C, and D in your pleading?
But by reference, my lord, yes. We're saying this is the misconduct upon which we rely, and these are the further particulars.
But not paragraph 42B.
My lord, no, we don't refer in terms to that in paragraph 24.
So that's not to be taken as included.
My lord, that's correct.
Nor E, F, or G.
No, my lord, we only seek to support paragraphs, the subparagraphs of 24 by the particular sub-paragraph references that we've included there.
I've followed that in relation to 24.2, but 24.3, the first sentence cross-refers to 43A to C, but as I understand it, the second sentence is derived from 43E, which isn't identified.
My lord, that's right, but it slightly goes back, or it does go back to my point that we don't need to incorporate the Brutus pleading at all for these pleadings, for this pleading in paragraph 24, when read together with paragraph 27 to be adequate.
You may not need to, but you have done. Albeit you've been very careful on particular paragraphs. Is that the position?
My lord, yes.
24.4, is that position tenable with 24.4? I mean, it doesn't identify the paragraphs. Can that stand unless we take it as cross-referring to the relevant paragraphs?
Well, my lord, in our submission, it is acceptable and a proper plea to plead a number of transactions with named Iranian entities and customers for whom the bank did business. And that has to then be read together with the other sub-paragraphs, because they obviously one feeds into the others.
But unless we look at the Brutus complaint, we have no idea what transactions are being referred to. And while it's said that the complaint names the entities, they're not identified in this pleading, and yet you're not cross-referring to the Brutus complaint.
My lord, we're not. But we say we don't have to when you read this pleading, paragraphs 24 and 27 together, which pleads a sufficient case.
Can 24.4 stand without relying on the Brutus complaint? I mean, taken on its own, it would be a pleading that there were a number of transactions with unidentified Iranian entities and customers.
My Lord, it would take on its own, but we say when fairly read with the other allegations.
Well, it still wouldn't identify the transactions
No,
or the entity.
It wouldn't, but that's why I started with the context, because
Are you, I mean, let's be explicit. Is there a reason why you are not adopting paragraph 46 to 59 of the Brutus complaint?
what? I've got to be slightly careful here about how much I say about the rationale that went into the pleading.
Well, we're told that the statements of truth are to be taken as confirming belief in the truth of the Brutus complaint so far as it relates to your allegation. Now, on the face of it, paragraph 24.4 relates to paragraphs 46 to 59 of the Brutus complaint. Are you to be taken as confirming your belief in the truth of paragraphs 46 to 59 of the Brutus complaint?
But, my Lord, I think the fairest way of putting it is that on the face of the pleading as it's drafted, no, because we don't expressly refer to those paragraphs in the Brutus complaint. But this, with respect, comes back to two things. One, whether when read alone or with the other subparagraphs that's a proper plea, in our submission we say it is. And two, the absence of any request for further information, because the request that my Lord just addressed to me is a request that of course could have been addressed by way of RFI, and the claimants could then have looked at that and decided how they answered it, whether they limited themselves as they do to the face of the pleading, or whether faced with a request made in that way, they then went further and said, in fact, we do rely on those paragraphs. And then, of course, the RFI response would have to be verified by a statement of truth as well.
But forgive me, 24, 2 and 3 identify paragraphs in the complaint. So the complaint is incorporated to that extent. And then you look at 24.4 and it says the complaint specifies a number of transactions. Well, which transactions that are specified are you there referring to? And as you say, you could have been asked which ones you're referring to. On the face of it, you're referring to them all. But if you're not referring to them all, can you tell us now which ones you're not referring to?
And I think the answer there would be the same answer that I've just given to my Lord Justice Newey, is that if the request had been asked, then the claimants could have answered that specifically.
No, but the court can ask you which ones are you referring to. We can ask you now. You say the complaint specifies a number of transactions. Well, which ones are you relying on? You must be able to tell us that.
Well, my Lord, we do rely on
which ones?
On all of them in the paragraphs that have been identified, but I have to be fair about whether we have pleaded those paragraphs. And as I've indicated, we do not here, in the same way as in the other subparagraphs, identify those particular subparagraphs in the complaint.
I follow that last point, but I think it would be helpful to know, at least by the morning, whether it is your position that the contents of paragraphs 46 to 59 of the Brutus complaint are true.
Well, I'll take instructions on that, because I want to make sure that I give as full an answer as possible.
Yes.
To that.
Well, 59 just sets out the 56.75 million figure. So you are saying that's true.
That's the source of the figure, yes, and we are saying that is true.
And isn't that based upon the transactions
which preceded.
Yeah. So if you're saying that 56.75 million is true, then you're saying that the other's true. Otherwise it wouldn't be 56.75 million.
My lord, as a matter of logic, that must follow. Now, so we've looked at the individual subparagraphs of paragraph 24, which provide the further particulars of the relevant misconduct as defined in paragraph 25 and 27. And I've made my submission that paragraphs 27, 25 and 24, when read together, are an adequate and proper plea of the relevant misconduct relied upon, including in relation to, in particular, the Brutus allegations, because of course paragraph 27 and 25 includes both Brutus and those allegations derived from the 2019 settlements, which is what led to, as I've already referred, the oddity that the judge noted about the application's focus on only 27.1 and 27.2. Now, in terms of the defence, it might be helpful just to see how Standard Chartered refers or pleads to these paragraphs in the defence. At tab 8 in the same bundle, page 222, at paragraph 26, beneath the heading "The Brutus Complaint," the defendant pleads to paragraph 24 of the particular claim at paragraph 26. And
I couldn't help noticing footnote 12 of the defence, which I can't imagine is going to be a point of great import either on this application or indeed at the 96-day trial.
My lord, one would hope not. But what one does see there, of course, is an ability on the part of the defendant to plead a positive case, starting, as my lord identifies, first of all, with who Mr. Knight is. And one accepts, as I hope I did, that while it may not have leapt from the page of the particular claim that Mr. Knight was the whistleblower, it's of course known to Standard Chartered that that is the case, and that's what's then pleaded to. And in particular, what's pleaded here is to the progress of the US proceedings.
I mean, that is one of the problems arising from how you pleaded your case. You pleaded that such and such was alleged, therefore Standard Chartered can reply to whether or not it was alleged, and they don't plead the detail of the Brutus allegations.
But they do, my lord, plead that the allegations are false.
They do plead that, but they don't, because of the way you put your pleading, bar explaining what they say about Project Green, they don't go into the rest of it. And they don't have to, because you only allege that it was alleged.
But they do, nonetheless, in paragraph 26.4, make the plea that the allegations are false and are denied, and then rely on paragraphs 27 to 29 below, where they do provide a degree of further particularisation, before at paragraph 30 on page 225, they note paragraphs 25 to 27 and then say that insofar as the relevant misconduct consists of misconduct referred to in the 2019 Statement of Facts, it is admitted, and insofar as the relevant misconduct comprises the further misconduct alleged in the Brutus complaint, that alleged misconduct is denied for the reasons set out at paragraphs 26 to 29 above. And so certainly at the time of pleading the defence, the defendant seemed to be, first of all, in no difficulty in pleading to these allegations, but secondly, insofar as paragraph 27 was concerned, it seemed to understand, as is the case, that provides particulars of misconduct derived both from the 2019 settlements and the Brutus complaint. And it then pleads to paragraph 27 and its subparagraphs compendiously by admitting misconduct insofar as it's referred to in the 2019 settlement and denying it insofar as it relates to Brutus. Now, the claimants then join
The problem with all of this, Mr. Chapman, I think, is this, that we end up with the defendant identifying matters, such as in 27.2, on this point about winding down, which is a point made in the Brutus complaint at 42b, which is the subparagraph you expressly don't incorporate into your pleading. So if you were the judge and this was the trial and you wanted an agenda, you'd be a bit baffled. Is winding down going to be a relevant issue for me to decide as the judge, or is it in fact no part of this case because 42b isn't incorporated? You see the point? It's just it's quite difficult to get hold of the pleadings.
My Lord, I see that, and there's an extent to which the parties have passed slightly like ships in the night, and one can see that the defendant has, for its own reasons, latched upon the way in which paragraph 24 is drafted. We would say, without fair regard to paragraphs 25 and 27, to plead where it wants to on the basis that paragraph 24 is said only to make allegations, or sorry, said to only to refer to the making of allegations by Brutus, while at the same time then pleading that those allegations, being allegations of misconduct, are denied without giving them particulars of the denial. And so there is, perhaps, if there is an absence of particularity, a particularity in both directions, and a certain degree of misfiring in the crossfiring. But that's something that, to the extent needs to be remedied, can be remedied. Not least through both parties, if necessary, asking requests for further information. But of course, one has to return really to, as I've indicated, the point of context, which is that, we'll come to the reply in a moment, that the focus of inquiry at trial is going to be on what the PDMRs knew of this misconduct. And therefore the focus will be on PDMR knowledge rather than in, as would be the case if this was a trial of the Brutus allegations and only the Brutus allegations, the granularity of each transaction being considered as to whether each transaction was a breach of US sanctions.
I mean, if the truth is that come trial, because of all the other allegations you're making, no one's going to care about the Brutus complaint, then we slightly wonder why we're here. You can do without it. But if that isn't the case, and you want to say that there are breaches of Section 90 and Section 90A because of the Brutus complaint, then it is going to be necessary at trial to look into whether there was actual misconduct.
Oh, my Lord, of course. But it will be through the prism of PDMR knowledge of that misconduct.
Well, obviously PDMR knowledge would be very important, but you have, in the first place, to establish that there was misconduct for them to know about.
And the most likely way to do that will be through the prism of PDMR knowledge, that the misconduct took place because of the body of evidence showing that not only did it take place, but the PDMRs were aware of it. That's really the point. There's not, I can't say there won't be. It's highly unlikely that there's going to be a trial of thousands of individual transactions. The position is going to be looked at through the prism of PDMR knowledge as to what senior individuals within the bank knew at particular times about breaches of US sanctions. And through that, of course, in order to make good their claims, because they will have to make good the allegations of falsity, the claimants will have to make good the allegations of relevant misconduct. But looking at it realistically, that's how the trial is likely to unfold. So top down rather than ground up, if I can put it that way. I was going to go next to the reply at tab 9, page 299, and to a passage which I think my Lord's have already seen. And that's paragraph 23.2. Where the claimants deny that the additional allegations of misconduct in the Brutus complaint are false. And then there's the subparagraph 23.2.3, which my learned friend took my Lord's to, which sets out the claimant's case. Which in our submission, and as the judge found, removed any doubt that there may have been.
I don't want to go too much over old ground, but on the face of it, I would read that as saying, given what's said in paragraph 24.4 of the Particulars of Claim, that you do believe paragraphs 46 to 59 of the Brutus complaint to be true.
What it says, my Lord, is that we, the claimants, believe those parts of the Brutus complaint which are then pleaded in paragraph 24, including 24.4, to be true. Now, whether I can say, absent the cross-reference, and this is the point I'm going to reflect upon overnight, I can incorporate by reference, or incorporate without reference, that those corresponding paragraphs in the Brutus complaint, leave on one side. What the claimants are saying here is that it is their case and they believe paragraph 24.4 to be true.
Yeah.
Now, those are the pleadings. The pleadings plainly feed into the case memorandum to which the judge referred and which we discussed. And as I say, I don't suggest or submit that the judge was suggesting that the case memorandum gives rise to some type of estoppel precluding the argument to be run, and I've indicated the way in which we suggest that the judge's observations need to be understood and read in that context. What we do say is that the judge was right to conclude, as I've put it, no doubt inelegantly, that when one stands back and looks at the course that the pleadings have taken, they are fit for purpose in articulating a sufficiently particularised case to which the parties can join issue, and upon which then suitable directions for trial can and indeed have been given. Now, I've covered much of what I was going to say about then the grounds of appeals, which I turn next in the course of going through the pleadings. And the first attack by my learned friend is what he describes as the speculative allegations point. And Lord, we say that the judge was right to reject this, right to find that the pleading was adequate, because when one reads paragraphs 24, 25 and 27 together, they do set out a proper plea relating to the additional misconduct upon which the claimants rely and which they plead in paragraph 27, and the particulars and basis for those additional allegations are to be found, first of all, in the 2019 settlements, to which no issue is taken in paragraphs 21 to 23, and secondly, and we would say substantively in character, no different, paragraph 24, which we've been spending some time upon. In effect, what the pleading provides is the allegations of particulars of wrongdoing in paragraph 27, and then the further particulars, or as my learned friend would put it, the primary facts for those allegations in paragraph 24. To put it another way, which my lords may or may not find helpful, paragraph 27 effectively sets out and pleads that this is what you did, and paragraph 24 sets out particulars of this is how you did it. Project Green, OLT3, the online portal, and so forth. Now, as I've indicated, paragraph 24 then goes further than that. We don't accept it active by identifying particular pieces of evidence that is relied upon in support of those allegations, namely the Brutus complaint, Mr. Knight, and the whistleblower piece. And in summary, and as found by the judge, and we say with respect, this was what was found by the judge in accepting our submissions and in going through the pleadings and the paragraphs that we've seen, the pleading is adequate, proper particulars are provided. And the answer, even if there was some doubt about that, and this is why, with respect, the judge deals with it in what I've described as the fitness and purpose sections of the paragraph. If there genuinely was any doubt about what was being pleaded or insufficiency in the particulars being provided in particular respects, the way to go about that was to ask for further information. And then there could have been a debate about the adequacy of any further information. But looked at in the way that I've hoped to analyse the pleading, we say the judge was correct to conclude that this pleading does satisfy the standard. Or put another way, the judge was right to conclude that the defendant had not satisfied him to the strikeout standard, that the pleading should be struck out.
Mr. Chairman, of course, in these modern days, it's certainly right that the usual practice would be to, as you say, put in an RFI. But we have to be slightly careful about that, don't we? Because ultimately the progression of a claim is a matter for the claimant, and there's no obligation on the part of the defendant to put in an RFI. And the defendant can sit on its hands and then object to later events and say, well, that's outside the pleadings.
My Lord, that's with respect right. The problem is where a defendant comes to the court and asks the court to strike out a pleading on the basis that the threshold test for the adequacy of the pleading is not met. And the rationale for that test is to ensure that a claim, particularly a claim in dishonesty, is adequately pleaded, so that the defendant understands the case it has to meet, and the court ultimately can deal with that claim. If an application is going to be made of that nature, then there has to be some real ambiguity or doubt about the what the pleaded case is, point one. And point two, if there is genuine ambiguity or doubt about what the pleaded case is, the first step that the defendant should take is to ask about it.
Well, forgive me, I personally don't accept that right. Either the pleading is adequate or it isn't. If it isn't adequate, there's no answer for the claimant who's provided an inadequate pleading to say the defendant can ask for RFI. If the pleading is adequate, then the RFI is irrelevant to that question. So I don't accept that it's any answer to a strikeout to say, oh, well, you can ask for RFI. You can ask for further information.
Well, I think there are two responses I would make to that, my lord. The first is that if the pleading is found to be inadequate, ordinarily the court, before taking the step of striking it out, will provide an opportunity to the pleading party to provide further particulars if it has found the pleading to be inadequate on the basis that it fails to disclose adequate particulars of the case.
Well, it might do, it might not. It depends as a case management decision as to whether to adjourn for that purpose. But that would be giving you the opportunity to do that, to salvage the pleading. It's not an answer to a strikeout to say you could ask for further information.
My lord, that's right. The process of analysis would be, has the applicant satisfied the court that this is an inadequate pleading, that it falls to be struck out under Rule 3.4? If yes, as a matter of discretion, do I, as the judge, immediately proceed to striking the pleading out? Or do I instead provide the pleading party with a final opportunity to remedy the deficiencies that I have accepted exist in its pleading case?
We haven't got to that stage.
No, we haven't, because the judge has found we say right.
I'm not sure at the moment where a request for further information comes into.
Well, it probably comes in, and I risk being criticised rightly for repeating myself, to the fitness for purpose argument. On the judge has, with respect, looked at the pleading and then in effect said, or asked himself, is it fit for purpose? Is there some real problem with the particularity here, which means that the defendant can't plead to it, or the parties can't move forward with their actions? And that's really the point. And what he's saying, we would suggest, is if there had been some real difficulty about it, you might have expected a request for further information to address that difficulty. That's not to go so far, and I don't go so far as to say, that a defendant must ask a request for further information in all cases before applying to strike out a pleading on the ground that it's inadequate. But that would be wrong for
Why don't they need to ask for further information in any case before applying to strike out if the pleading is inadequate?
My lord, that's right, and the pleading party stands or falls on that.
Why do we need to deal with requests for further information at all on this?
Only because of the way the judge has dealt with it, in the sense that it is part of the consideration of whether this pleading is fit for purpose, and he found that it was, and we say he was right to do so. Just as my Lord Justice Coulson identified, that it is relevant. I don't say it weighs terribly heavily in the balance, but it is relevant that there was a significant delay before the application was brought on. Made.
Well, I can see it might be open to a judge to decline to hear a strikeout application on the basis it's brought too late in the day, or because events have moved on too far by way of disclosure, evidence being exchanged. And it seems to me it would probably be within his case management powers to decline to hear the strikeout application or to adjourn it to the end of the trial or something like that. It doesn't seem to me that delay is relevant to the pure question whether a pleading discloses a proper case in full on its face.
My Lord, only to the limited extent, and I hope I've made it clear that the limited extent to which I've indicated in the limited extent to which the judge, in our submission, has taken such factors into account.
Yes, I think what I'm putting to you is I don't think they are relevant, and I don't know why the judge took them into account. I can't see that either the possibility of asking for further information, or delay, or indeed the alleged concession in the case management, or the fact that the defence in pleading, any of those matters are relevant to the strict question of whether your pleading was adequate, an adequate pleading put forward on its face.
Well, look, perhaps I can put it this way. Those factors may embolden and support the decision reached on an analysis of the pleading itself as to its adequacy.
And is that going to be a convenient moment?
My Lord, yes.
And I would infer from what you've been saying, you won't have that much more to say about the Brutus complaint aspect.
My Lord, that's correct.
So you've got plenty of time on Maxpower in the morning.
I would hope so.
10:30.